fabulous, great.
Offensively on the second
I
amendment.
put my coat
Yeah.
in my bag.
Actually, I'm suing DC.
Yeah.
Right, really?
No, at 3:30, right, when the panel is over. I can stay for nice to meet you, Dan. That's your chair. I assume this is mine.
Just speak from down here. Up there.
Except for Q&A.
Oh, it is. Great. Wonderful. I still have to leave. Guys, I've got a 4:30 flight, so I think that's pretty tight.
Through the Q&A, or you have to leave right after you
Oh, fabulous. So should I, would you mind walking me out? No, great, because otherwise I'm inclined to talk to people and then I, get late. Thanks a lot, Dan.
Rebuttal. We'll do, you each do 12 minutes, and then we'll open up for Q&A, because I think we'll have a lot of Q&A.
Annie, ready to go?
So are you unpacked yet?
Barely. Barely.
And you
Good afternoon.
Yeah.
Good afternoon.
Good afternoon.
I was blessed as a child with a loud voice. It meant I spent a lot of time in the principal's office, but in 20 years as a judge, I've never had trouble bringing a courtroom to order. My name is Richard Wesley. I'm from the Second Circuit Court of Appeals. It's a great pleasure to be here today. I've enjoyed the opening remarks and the panels that preceded us, but today, this afternoon, I think we're going to get down as lawyers to where the rubber meets the road. We're going to get a little bit more specific about liberty and individual freedom in times of difficulty. It occurs to me that there are three events in the course of our nation's experience that have really transformed our nation and become pivotal times in the American experience. Those three are the battle at Fort Sumter, which began the beginning of the Civil War, Pearl Harbor, which began the opening of the Second World War for the United States, and September 11th in 2001. All of you will remember September 11th as a day you'll recall where you were and what you were doing. I was at the New York Court of Appeals preparing for oral argument in the afternoon and watched the second plane hit the building. I was standing with my good friend George Bundy Smith, whose chambers were at Beaver Street, not 3 blocks from the World Trade Center. It's interesting to note that during the Gore-Bush debates, there was not one single question with regard to terrorism in the United States. What a difference one day makes in the American experience. We have a panel of all-stars here today to talk to you about terrorism and civil liberties. And I want to get right along and introduce them. I'm going to not introduce them in the order in which they speak. They're in the order in which my law clerk and I assembled the bios before I knew the order of speaking. And that's not her fault, because she hasn't had the book back for some time. Our first speaker, one of our speakers today will be Professor Nadine Strawson of the New York Law School. She's written, lectured, and practiced extensively in the area of constitutional law, civil liberties, and international human rights. Since 1991, she has served as the president of the American Civil Liberties Union, the first woman to head the nation's largest and oldest civil liberties organization. Professor Strawson knows this campus quite well. After graduating Phi Beta Kappa from Harvard College, she went on to the Harvard Law School, where she served as an editor of the Harvard Law Review and graduated magna cum laude. Professor Strawson then returned to her hometown of Minneapolis, where she practiced law for several years before returning to New York City. Among her many awards and accolades, Professor Strawson has twice been named one of the 100 most influential lawyers in America by the National Law Journal and one of America's 100 most important women by the Ladies' Home Journal. She has written and lectured extensively in the area of civil rights and civil liberties. We are delighted to have her here with us today. Also with us today is Professor Jack Goldsmith. Jack Goldsmith is a professor of law here at Harvard Law School. He received his B.A. in philosophy summa cum laude from Washington and Lee University, a B.A. in philosophy, politics, and economics, and first honors class from Oxford University, a J.D. from that other law school in New England, Yale Law School, and a diploma in private international law from the Hague Academy of International Law in 1992. After law school, he clerked for Judge J. Harvey Wilkinson of the U.S. Court of Appeals for the Fourth Circuit, Justice Anthony Kennedy of the United States Supreme Court, and Judge George A. Aldrich of the Iran U.S. Claims Tribunal. Before coming to the law school, Professor Goldsmith was a professor of law at the University of Virginia School of Law and at the University of Chicago. Professor Goldsmith has also served as special counsel to the General Counsel at the Department of Defense and as the United States Assistant Attorney General for the Office of Legal Counsel. There he assisted the Attorney General in his function as legal advisor to the President and all the executive branch agencies. Professor Goldsmith now teaches on conflicts of law, emergency powers, no surprise, and presidential power at Harvard Law School and is visiting scholar at the American Enterprise Institute. Dr. Daniel Pipes is here with us also. Much like Professor Strawson, Dr. Pipes is no stranger to Cambridge. He received his bachelor's and his PhD from Harvard, both in history. He then spent 6 years studying abroad, including 3 in Egypt. He has taught at the University of Chicago, at Harvard, and at the U.S. Naval War College. In addition to his academic positions, Dr. Pipes has served in various capacities at the Departments of State and Defense, including serving as Vice Chairman of the presidentially appointed Fulbright Board of Foreign Scholarships. Dr. Pipes is now Director of the Middle East Forum, a think tank that works to define and promote American interests in the Middle East. In 2003, President Bush nominated him to the board of the United States Institute of Peace, where he served for the past year. Dr. Pipes has written 12 books on Islam and the Middle East and is a prize-winning columnist for the New York Sun and the Jerusalem Post. He is a frequent commentator on such programs as ABC, CBS Reports, Good Morning America, and by the way, I turned on my television this morning, and at 8:15 he was on Fox News, somewhere in Boston, and Nightline, where he discusses current issues. Dr. Pipes has also appeared on leading television networks around the globe, including the BBC and Al Jazeera. Last but certainly not least, and who will be our first speaker today, Dr. Robert Levy is a senior fellow in constitutional studies at the Cato Institute in Washington, D.C. He joined Cato in 1997 after 25 years in business. Dr. Levy received his PhD in business from the American University in 1996. He then went on to found CDA Investment Technologies, a major provider of financial information and software. He served as Chief Executive Officer until 1991. Upon leaving the business world, Dr. Levy entered law school at George Mason University, where he earned his J.D. in 1994. At George Mason, he served as Chief Articles Editor of the Law Review. During the next 2 years, he clerked for the Judge Royce C. Lambert of the U.S. District Court in Washington, D.C., and for Douglas H. Ginsburg of the United States Court of Appeals for the District Circuit. I think it's Chief Judge Douglas H. Ginsburg of the United States Circuit Court of Appeals. Dr. Levy is now Director of the Institute for Justice and a member of the Board of Visitors of the Federalist Society. He's written numerous articles on investments, law, and public policy. His writing has appeared in the New York Times, the Wall Street Journal, the Washington Post, and the National Review, among other publications. It's my great honor, ladies and gentlemen, to introduce to you Dr. Robert Levy.
It's great to be with you. Today I'm going to some comments regarding 2 of the Supreme Court's terror cases, namely the Padilla case and the Hamdi case. Padilla is the U.S. citizen who supposedly plotted to detonate a dirty bomb and then use natural gas to blow up some apartment buildings in Washington, D.C., New York, and Florida. And since his capture, not in Afghanistan, but at Chicago's O'Hare Airport, he hasn't been charged with any crime at all. And yet, from June of 2002, Padilla has been held incommunicado in a South Carolina military brig, indefinite detention, without even access to a lawyer, until March of 2004, nearly 2 years after his incarceration. The Supreme Court addressed this case in Rumsfeld v. Padilla, and basically the court ducked its opportunity to decide whether Padilla's detention is permissible. Chief Justice Rehnquist, joined by the other conservatives on the court, held that Padilla should not have sued Donald Rumsfeld in New York, but instead he should have sued his immediate custodian, who was the head of the military brig in South Carolina. So the result, Padilla had to start all over again and refile his petition in South Carolina. So what happens next in the Padilla case? Some of the news reports have indicated that Padilla might be indicted by the Justice Department at last, after almost 3 years, charged with a crime. Here's what the government claims in its declaration. It says that Padilla was an enemy combatant, and he was, and I'm quoting now, closely associated with al-Qaeda, had engaged in warlike acts, including conduct and preparation for acts of international terrorism, had intelligence and could assist the U.S. to ward off future terrorist attacks, and was a continuing threat to U.S. security. The government did not allege, however, that Padilla was indeed a member of al-Qaeda. And then, just prior to the Supreme Court's decision this past year, the Justice Department issued yet another report, this one on Padilla's interrogation. Supposedly, during his interrogation, Padilla admitted that he attended al-Qaeda training camps, discussed a bomb, discussed the use of natural gas to blow up these apartment buildings, but of course bear in mind he had no lawyer present, so the evidence wouldn't be admissible in court. His appointed lawyer met Padilla for the first time in, as I said, March 2004, which was after the interrogations. And once the attorney, met with Padilla, the lawyer was placed under a gag order. She wasn't even permitted to say whether or not Padilla disputed the allegations. So in other words, really no defense was possible. And yet, in accordance with a footnote in the report that the Justice Department issued, Padilla did, during the course of this interrogation, deny any allegiance to al-Qaeda, denied the bomb plot, and says that he discussed the plot only because he wanted to avoid fighting in Afghanistan. Well, I doubt really that the government has a compelling case. If it did, the Justice Department would have filed charges long ago, but that doesn't mean that some deal won't be reached. And the reason I think a deal might be reached is because the logic of the other case that was decided the same day, namely Hamdi v. Rumsfeld, suggests that the alternative to a deal with Padilla, like it or not on the part of the government, is to release Padilla. So let me explain the link between the Hamdi and the Padilla cases, because Hamdi, as I'm sure you recall, is the other U.S. citizen who was detained incommunicado for nearly 3 years. The major difference is he was captured on the battlefield in Afghanistan, not at O'Hare Airport like Padilla. In the Hamdi case, Justice O'Connor was joined by Rehnquist, Kennedy, and Breyer, and held that the government, and I quote, may detain for the duration of these hostilities individuals legitimately determined to be Taliban combatants. And Thomas agreed with that, thus a majority. He filed actually a dissenting opinion, which tipped even further toward executive power. So a majority of the court clearly authorized Hamdi's detention. So why is it that I suggest that Padilla is going to have to be released if he's not charged? Well, for 4 reasons. First, interpreting Padilla's case in light of the Hamdi opinion. The Hamdi opinion suggests that the war on terror would not justify Taliban detentions once active hostilities in Afghanistan had ended. Arguably, they have ended. Second, and I think a more compelling argument, the court said in Hamdi that Hamdi's detention was justified to prevent combatants from returning to the battlefield. But of course, Padilla did not come from the battlefield. He was not one of the Taliban combatants. The third point that Hamdi's opinion made, the Supreme Court's opinion, said that executive detention was permissible in Hamdi's case, but only because Congress had authorized it. And the reason it was necessary for Congress to authorize it is because there's a 1971 statute called the Non-Detention Act. And here's what the Non-Detention Act says, and I quote, "No citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress." Now, arguably, the resolution passed by Congress post 9/11 did trigger the President's Commander-in-Chief authority, and that would include the power to apprehend enemy soldiers, certainly in a zone of active combat. And that could be argued that justifies Hamdi's detention, but not Padilla's. The President surely could not order the imprisonment without charge of an unarmed non-soldier far from active combat, especially a U.S. citizen apprehended on our own soil. The fourth reason to predict that Padilla will be charged or released is this. If Padilla returns to the Supreme Court, if his case goes up again, he should have at least 5 solid votes to set him free. One vote, of course, would come from Justice Scalia. Scalia dissented even in the Hamdi case and concluded that Hamdi should be released unless he's charged with a crime or treason, or Congress suspends habeas corpus, which of course Congress has not done. The remaining 4 votes, aside from Scalia's for Padilla's release, would come from the 4 Padilla dissenters. It was a 5-4 case. All 4 liberals dissented, Stevens, Breyer, Souter, and Ginsburg. They wanted to reach the merits of the case. They didn't want it dismissed on the grounds that Padilla should have sued elsewhere. And here's what they argued, I quote, "Executive detention may not be justified by the naked interest in using unlawful procedures to extract information. Incommunicado detention for months on end is such a procedure." Then it went on to say that Padilla's detention was a form of torture, like the Star Chamber. Well, as I said, Padilla has refiled his case in South Carolina to comply with the Supreme Court's venue decision, and then he moved for summary judgment in South Carolina. In response to that motion, the latest development is that the Justice Department has now declared that Padilla carried an AK-47 with al-Qaeda and Taliban forces in Afghanistan while U.S. soldiers were present. They make this argument because they want to use the Hamdi decision, which says that the President can detain enemy combatants in the zone of active combat. They want to use that decision to justify Padilla's detention. Interestingly, the government's original declaration regarding Padilla didn't mention any Afghan combat role for Padilla. And moreover, the Justice Department has posited a completely different argument in its Supreme Court briefs. The Justice Department argued in its briefs that the zone of combat, which is mentioned in the Hamdi case, should be expanded to include O'Hare Airport. Well, Padilla's attorney has a different story. First, he dismisses the O'Hare argument as utter nonsense, and second, he argues that the government's allegations regarding Padilla's combat role are really untrue and based on unreliable witnesses. Now, it is the case that on summary judgment, the judge may decide that he's bound by the Justice Department's version of these facts, and that means the government may succeed in what I believe to be a pretty cynical ploy, which basically is delaying Padilla's release for yet more months until there's an evidentiary hearing and an appeal when, in my view, Padilla will ultimately prevail. Now, not surprisingly, the administration has touted the Padilla and the Hamdi cases as a victory for executive power, but I think that's just spin. In 2003, the U.S. Court of Appeal for the Fourth Circuit rejected the government's primary argument, which was that the courts can't second-guess the military in identifying enemy combatants. In 2004, the Supreme Court rejected the government's fallback argument, and that was that the government just has to produce some evidence to support its enemy combatant designation. Instead, the doctrine now is, according to the Supreme Court, that citizen detainees get a lawyer and a fair opportunity to rebut the government before a neutral decision maker. And partly because of that view in the Hamdi case, the Defense Department announced in September of last year a deal for Hamdi's release. Hamdi renounces his U.S. citizenship. He moves to Saudi Arabia, where he's also a citizen. He consents to travel restrictions and to be monitored by the Saudis, and he agrees not to sue the U.S. for civil rights violations. Well, that deal simply cannot be viewed as a victory for the administration. I mean, think of the implications of Hamdi's release. In 2002, the government contended in court that merely allowing Hamdi to meet with counsel, quote, jeopardizes compelling national security interests, interferes with, if not irreparably harms, the military's ongoing efforts to gather intelligence. The Justice Department went on to say Hamdi might even pass concealed messages through unwitting intermediaries. Well, now Hamdi's free, so the government presumably believes that he's no longer a risk. The question is, why did it take 3 years of incommunicado detention to reach that conclusion? Well, the real reason that Hamdi is free is because the Supreme Court, in effect, has mandated his release. Now, finally, administration supporters ask this, I think, important question about Padilla. Suppose, and Padilla, by the way, is allegedly far more dangerous than Hamdi was. Suppose President Bush had indeed released Padilla, and Padilla proceeded to blow up parts of New York. No doubt a number of Bush's critics would have sought his impeachment. Well, naturally, that same dilemma exists whenever anybody is released for lack of evidence and then goes ahead and commits a crime. But I think it's fair to say this. In the case of suspected terrorists, the stakes are immense. So a powerful argument can be made for changing the rules, for tilting the rules toward national security, even if some civil liberties might be compromised. But if we do change the rules, the process cannot be unilateral. It can't be implemented by executive edict without any congressional input. And it can't be law on the fly, with no knowledge of the rules by anyone other than the executive officials who are responsible for their enforcement. This is not the time for Congress to abdicate its lawmaking role. Congress, bound by the Constitution, has to set the rules for detention of terror suspects, and the sooner it does it, the better. Padilla may very well deserve the treatment he's receiving, maybe worse. That is not the point, however. When American citizens are taken into custody, they have, at a minimum, the right to consult an attorney, and then Congress and the courts, not the President, should decide whether the arrest and the imprisonment comport with the law and the Constitution. Thanks.
Thank you very much for inviting me. I apologize, I have a bad cold. I'm going to approach the panel topic from a little bit higher level of abstraction, asking the question, what does it mean? Well, here's the general question I think we're supposed to address. What does it mean to have a liberty interest in war, which is a social context in which the President has significantly heightened powers and can legally kill people on the battlefield without giving them any due process at all? That's what war, that's one of the things it means to be in a war. How do we define freedom in this context, and how should courts police freedom in this context? This is a large question, and I have less than 12 minutes now. I'm going to first suggest that a very simple distinction does almost all of the work in explaining Supreme Court decisions, and then I'm going to try to explain how that principle, that distinction, should be applied in the war on terrorism. The simple distinction is between enemy combatants and civilian non-combatants. If you wage a war on behalf of the enemy, you can legitimately expect to have significantly diminished freedoms during wartime. If you don't fight on behalf of the enemy, you should not expect significantly diminished freedoms during wartime. Now, contrary to conventional wisdom, the phrase enemy combatants is not a new one. The Supreme Court used it in its several World War II decisions to describe basically members of enemy armed forces. It was the general category used to describe members of the enemy armed forces regardless of whether they were prisoners of war or unlawful combatants. So the distinction between enemy combatants and civilian non-combatants is a fundamental, probably the fundamental distinction in the laws of war, so fundamental that it's called the principle of distinction in the laws of war. The laws of war permit wartime belligerents to target and kill combatants and to capture and detain them until the end of hostilities. It's a core principle of the laws of war. But it is a violation of the laws of war to target and kill civilian non-combatants or to engage in combat while failing to distinguish oneself from civilians. And all of the celebrated Supreme Court civil liberties decisions during wartime, all but one, and I'll talk about that in a second, the combatant-civilian distinction was crucial. So consider 4 cases. The Milligan case, the famous Civil War decision striking down the use of military commissions. The court struck down the military commissions against a non-prisoner of war. That was important to the court's distinction. It was a civilian who was not fighting for the enemy. In Ex parte Endo, in the World War II, the Supreme Court invalidated the detention of loyal civilian Japanese Americans precisely because they were civilians, not enemy combatants. In Duncan versus Kahanamoku, another World War II case, the court invalidated military commission trials of civilians in Hawaii at a time when it was under martial law. And of course, in the Youngstown Steel case, the court invalidated the commander-in-chief's attempts to seize civilian property. All these decisions, in effect, engaged in heightened judicial scrutiny when the executive branch took the actions and questions against non-combatants. And they all recognized, explicitly or implicitly, that the analysis would have been much different if the executive had taken the actions in question against enemy combatants. Now, Korematsu, the famous Korematsu case, is an obvious counterexample. There, the court upheld the exclusion procedures, the exclusion of innocent Japanese Americans. But I think that the modern repudiation of Korematsu is based precisely on the conclusion that it was inappropriate to intern civilians not specifically linked to the enemy. And I think the best evidence of that is that there's been no similar repudiation in modern times of the fact that in the United States during World War II, we detained hundreds of thousands of prisoners of war, enemy combatants, including dozens and probably hundreds of Americans. The difference between the reaction to Korematsu and the reaction to that is precisely the difference between executive power against enemy combatants and non-enemy combatants. Also, if you look at the decisions upholding presidential authority in wartime, the same distinction is important, and I have only time here for one example, and that is the 1942 Kirin decision in the Supreme Court, in which the Supreme Court upheld the use of military commissions against 8 German Nazi saboteurs captured in the United States, 2 of whom were Americans. They upheld the use of military commissions to try and punish and execute 6 of the 8 of the Nazi saboteurs, and distinguished the Milligan case, the World War II precedent, precisely along the lines I'm suggesting. Milligan was not an enemy combatant. The Nazi saboteurs were. There are many other examples which I don't have time to go into. So how does this distinction map onto the war on terrorism? How does it have to change, if at all? The enemy combatant framework is admittedly much harder to apply in the terrorism context than it is in the traditional interstate war context. One reason for this, and I'll discuss more in a moment, but there are many, many more which perhaps we can talk about in the discussion, is that not every terrorist act constitutes an armed conflict that triggers authorities under the laws of war. Excuse me. That problem, though, the problem of figuring out which terrorist acts trigger the laws of war and the President's authorities under the laws of war, is significantly diminished in this context, in the context of the post-9/11 war on terrorism, precisely because Congress has decided that the 9/11 attacks were armed attacks that triggered the laws of war. They did so, there was a sufficient magnitude to trigger a military response and to trigger the President's authorities under the laws of war. Congress did this on September 18th in its authorization to use military force, which authorized the President to use all necessary and appropriate force against the nations, organizations, and persons who were responsible for the 9/11 attacks. Now, the authorization to use force in September of 2001 builds on developments in the international laws of war that themselves recognize that armed conflict with terrorists can trigger the laws of war and the authorities of the laws of war, and I might add the limits of the laws of war as well. So the bottom line is, one more thing, I'm sorry. The September 18th authorization by Congress also goes a long way towards defining who the enemy combatants are. It defines them as the nations, persons, and organizations who, and I'm paraphrasing, there's a lot of words there, but who were, in general terms, responsible for the 9/11 attacks. So the bottom line is those who fight on behalf of or who have adequate connection to those persons and organizations who committed the 9/11 attacks are enemy combatants and have some significantly diminished expectations of freedom compared to innocent civilians. I think it follows that enemy combatants fighting on behalf of al-Qaeda and related terrorist organizations with an adequate nexus to al-Qaeda itself can be detained. I'm going to focus on detention now. This is just one element of one authority under the laws of war. Can be detained until the end of hostilities. But I think that this conclusion, this traditional presidential power, is going to have to be qualified because the war on terrorism places 2 significant pressures on the combatant-civilian distinction, or places pressure on it for 2 reasons. One is because the enemy flaunts the laws of war and does not distinguish itself from civilians, the enemy in this war, and because it tries to render the civilian combatant distinction meaningless, one consequence of that is a heightened likelihood of mistake. It's one thing to capture persons on the traditional battlefield wearing uniforms. They self-identify and mistakes are minimized. It's another thing to capture enemy combatants when they don't distinguish themselves from civilians. The likelihood of mistake is heightened. Second, the costs of a mistaken decision are heightened as well, because we have a difficult time even imagining what a cessation of hostilities, the end of the conflict with terrorist organizations looks like. We can't imagine a peace treaty or an armistice. And so this is why many people think that detention as an enemy combatant in this war means indefinite and perhaps permanent detention. Those 2 reasons are going to put significant pressure on the combatant distinction. I don't think, however, that they affect the core legitimacy of significantly reducing the freedoms of wartime enemy combatants. I think it still remains legitimate to detain them until the end of the conflict. But I do think these differences will result in two types of procedural changes. These have already started to happen, related to the identification and detention of terrorist enemy combatants. The first is designed to minimize mistakes in determining who is an enemy combatant. I just told you that there was a heightened likelihood of mistake, and I think that that's going to result in significantly heightened procedural protections for persons whom the executive thinks or claims to be enemy combatants. And I think those protections are going to come both within the executive branch, procedural protections guaranteed within the executive branch, and with heightened judicial scrutiny of the executive branch determinations. And in a nutshell, what I just said is what I think the essence of this is the essence of what the Supreme Court decided in the Hamdi and Rasool cases. Basically, the court reaffirmed the executive had the power to exercise traditional military authorities against enemy combatants, but insisted on significantly greater procedural protections during the combatant status determinations in order to minimize errors. So this first procedural change, I think, is essentially the one embraced in Hamdi and Rasool. The second change will come in how we conceptualize the end of hostilities. The purpose of detention in wartime is not punishment. You do not have to charge an enemy combatant with a crime to be able to detain the enemy combatant. That is an old rule, and I think it should apply no differently here. Now, traditionally, the laws of war determine the end of hostilities on what you might call a categorical or group-based basis. Namely, hostilities ended when the hostilities between the enemies, states, ended. Here, in the war on terrorism, because it's so difficult to conceptualize that end of the conflict, I think, and this has already started to happen again, the categorical approach makes less sense, since we can't imagine when the end of, we can't conceptualize easily when the end of hostilities will obtain, and they will have an alternate approach. The alternate approach will not focus on the question of whether hostilities have ceased with al-Qaeda and related terrorist organizations, but rather whether hostilities have ceased with the individual enemy combatant detainee, i.e., whether the individual enemy combatant detainee continues to pose a substantial danger of rejoining hostilities. If the individual does not pose a danger of rejoining hostilities, then you might say the purpose of detention has dissipated and the detention should dissipate. Now, I don't have time, I'm out of time now to develop the idea further. That's obviously easier said than done. The United States has been, the executive branch, under pressure from both foreign nations and the Supreme Court, has been groping towards just this process. There are many models for this process of administrative detention and release from other contexts. I think that that is how hostilities will be determined to end, on an individualized basis, akin to an administrative process. And that's all I have to say. Thanks.
Good afternoon, everybody. Good afternoon. I'm used to students responding. I'm so happy to address this symposium and also to be a regular speaker at many Federalist Society forums. I always start, so those of you who have heard me before, this will be familiar, but it's a very important starting point for all of my Federalist Society presentations to remind all of you of the libertarian founding principles of this organization, which could come straight from the ACLU's policy guide and which are directly relevant to this panel's topic. In your mission statement, opening words, the Federalist Society is founded on the principle, and the first one listed is, the state exists to preserve freedom. It goes on, the Society seeks to reorder priorities within the legal system to place a premium on individual liberties. Also key to this panel's topic, your mission statement declares that the separation of governmental powers is central to our Constitution, and that tied in very much with both of the two preceding speakers' remarks. Now, in 1994, I was on a Federalist Society panel with one of your illustrious founding gurus, Irving Kristol. And as usual, I started by reciting these libertarian tenets of your group, and that sent him into a state of shock, quite literally. Our discussion was published, so I'm going to read to you his response. Quote, "I am shocked to discover that the Federalist Society seems to have said somewhere that the state exists to preserve freedom. The Federalist Society should call a meeting immediately and change that. You say this, and you get yourself into the kind of trap that Ms. Strawson has now sprung. Well, I periodically reread the website of the Federalist Society with trepidation, worrying that you might have followed Irving Kristol's advice, but I'm delighted to find that so far that has not been done, so you are again trapped when it comes to the topic of the present panel, and remember, it was not me who said that, but Irving Kristol. I also want to stress, though, that the many conservatives as well as libertarians have agreed with the ACLU on the overall theme of this panel, that too many post-9/11 measures have unjustifiably sacrificed our freedom without sufficiently advancing our security. So our very extraordinarily diverse coalition partners with whom we have been running what we call our Safe and Free campaign post-9/11 include many prominent libertarians and conservatives, in other words, both wings of the Federalist Society. What we've done is to analyze each touted security measure individually to ensure that it really does maximize national security with minimal cost to civil liberty. And of course, those of you who have studied constitutional law will recognize that this is the close judicial scrutiny test that the Supreme Court uses whenever there is an infringement of a fundamental right. But I also want to note that that test squares very much with common sense. After all, why should we give up our freedom if we don't gain security in return, or if we could gain as much security without giving up as much freedom? Applying this constitutional and common sense test to the many post-9/11 policies that have been implemented or proposed, there are many that have passed it, which we and our diverse allies have not criticized. For example, of the 160 separate provisions in the USA Patriot Act, we have only criticized about a dozen. Now, those dozen are very dangerous, and I don't want to minimize the dangers, but I do want to put it in the context of a law that is much more extensive. Moreover, even concerning the provisions that we have criticized, we have not advocated repeal, but rather reform. In fact, the only person that I can remember calling for a wholesale repeal of the entire USA Patriot Act was that great radical Al Gore. Far from the position of the ACLU. I am saying that with a great sense of irony. And the reform that we are advocating is simply to instill judicial review, again consistent with the remarks that have been made by both of the other two panelists so far, to bring the government powers, the new powers, into line with basic constitutional values. This constrained and constructive criticism hardly warrants the charge that John Ashcroft leveled against his critics while he was Attorney General. He called us hysterical, literally. If anything, the extreme position is the one that's been taken by not only John Ashcroft but others now in the administration, refusing even to consider even any reform to even a single provision in the entire 350-page Act. Rather, the administration's absolutely adamant, unyielding position has been that the whole law must remain in effect without a single amendment and even without honoring its sunset provisions, which are due to come into effect at the end of this year with respect to about 15 of the law's controversial provisions. I think that position is as irrational as the Al Gore position of we should repeal the whole thing, hook, line, and sinker. This extreme assertion of executive authority has characterized too many other post-9/11 policies, including the one that Bob Levy outlined about assertion of unilateral executive branch power to label anyone, even an American citizen, a so-called enemy combatant without any of the procedural protections that Professor Goldsmith has advocated. I think it's so striking that the Supreme Court rejected that extreme assertion of unilateral executive branch authority by the resounding vote of 8-1, with only Justice Thomas dissenting on that point, especially when you consider the fact that the current justices are very supportive of executive authority in general, and specifically supportive of the authority of this particular president, given their ruling in Bush versus Gore. So I think that their rejection of this assertion of presidential power really carries a lot of weight. And that important decision in the Hamdi case has set the tone for other judges who have struck down other post-9/11 measures as unjustifiably violating our rights. I'd like to mention just one example, a victory that the ACLU won last September. In the first court case to rule on any of the Patriot Act's sweeping new surveillance powers, and I'm putting that term in quotes, that's what John Ashcroft himself used when he described it, the first case to consider any of those sweeping new surveillance powers, the court agreed with us that they violated fundamental constitutional rights, including First Amendment rights. Specifically, the court struck down the Act's enormous expansion of the government's power to spy on us secretly through so-called national security letters, getting access secretly, unbeknownst to us, to such private materials as our Internet communications records without any judicial review whatsoever. Just as the administration's excesses have been criticized by even conservative Supreme Court justices, the same is true for conservative members of Congress. In fact, one of the strongest critics of the Patriot Act is actually a member of the House Republican leadership, Alaska Congressman Don Young. Here's what he said about the Patriot Act. Everybody voted for it, but it was stupid. It was emotional voting. We didn't study it. It's the worst piece of legislation we've ever passed. Now, I think that's probably hyperbolic, but again, it didn't come from the ACLU, came from a member of the House Republican leadership. Moreover, the congressman who has been leading the charge to cut back on the Patriot Act's excesses is another conservative Republican, Butch Otter from Idaho. He sponsored a measure, the so-called Otter Amendment, to counteract another one of the Patriot Act's overreaching provisions, the one that allows so-called sneak and peek searches, secret government searches of your home or your office without any notice to you until long afterward, when it would be too late to protect your precious privacy rights. The House of Representatives passed the Otter Amendment with an overwhelming vote, which included almost half of all House Republicans. And we see the same pattern in the Senate, with broad bipartisan support for the key measure that would cut back on the Patriot Act's excesses, the so-called SAFE Act, and that is an acronym for Security and Freedom Ensured. The SAFE Act's co-sponsors include such conservative Republicans as Senators Larry Craig of Idaho and John Sununu of New Hampshire. So the Bush administration is dead wrong when it keeps trying to dismiss the criticism of its post-9/11 excesses as a mere partisan attack. Worse yet, of course, was the accusation by then-Attorney General Ashcroft that those of us who criticize civil liberties violations are unpatriotic or even traitorous, and I want to show you that I'm not exaggerating. To quote his exact words, he said, "We only aid terrorists and give ammunition to America's enemies." That reminds me of a recent headline in one of my favorite publications, The Onion. You thought I was going to say the Harvard Law Review, right? This particular Onion headline read, "Bush asks Congress for $30 billion to help fight war on criticism." In the ACLU's post-9/11 campaign to keep our great country both safe and free, our allies have included conservative citizens groups as well as officials, everything from the American Conservative Union to Americans for Tax Reform to Phyllis Schlafly's Eagle Forum to major gun owners organizations. Let me quote, for example, Wayne LaPierre, the head of the National Rifle Association, speaking to his membership. He said on these issues, he said, "Maybe you think that with President George W. Bush in the White House, everything is safe. You think you can put aside your principles just this once to be a loyal conservative. But if we as conservatives don't stand up for these fundamental truths, who will? Never accept the idea that surrendering freedom, any freedom, is the price of feeling safe." In the same vein, we've also heard strikingly strong criticism of post-9/11 executive excesses from the so-called religious right, conservative Christians who are worried about the Attorney General's new investigative guidelines that allow surreptitious surveillance and infiltration even of religious worship services. I'd like to close by quoting one of the most recent court decisions that agreed with the ACLU and our many libertarian and conservative allies that we need not sacrifice our freedom to ensure our security. In November, the 11th Circuit Court of Appeals, in a unanimous panel decision, upheld our challenge to efforts by officials in Columbus, Georgia, to invade the privacy and free speech rights of participants in a peaceful demonstration against torture and other human rights abuses. The officials asserted that the war on terrorism warrants curtailment of civil liberties in general, including the rights of these peaceful protesters in particular, but the court resoundingly rejected these claims. As it eloquently declared, my closing words, we cannot simply suspend or restrict civil liberties until the war on terror is over, because the war on terror is unlikely ever to be truly over. September 11, 2001, already a day of immeasurable tragedy, cannot be the day liberty perished in this country. Thank you.
Good afternoon, ladies and gentlemen. I'm delighted to be present at a Federalist Society event. I've watched it for many years from the sidelines and with great admiration. I have two apologies. Not only do I have a cough, but I have to leave at 2:45, so I will in fact probably leave before you have any chance to throw questions at me. This panel was given 3 topics to choose from. 2 of them, about precedents in the Supreme Court, are suitable for legal experts, which you heard my biography. I emphatically am not. So I've chosen to take up the 3rd of these topics. In general, the question goes, has the balance between waging the war on terror and protecting civil liberties slipped too far towards the war on terror, to the detriment of civil liberties, or the reverse? Which I would summarize by saying, to what extent must Americans give up civil liberties for the sake of national security? This is a divide, this is a debate that goes back through U.S. history. Notably in the Civil War and World War I, there were many debates, profound debates on these issues. It was then renewed at the beginning of the Cold War, this time with a partisan liberal conservative edge, subsided somewhat in the 1990s, and began anew with 9/11. The profound sense of unity that existed in the aftermath of September 11, 2001 was quickly dissipated as conservatives were profoundly affected by the event and liberals far less so. In fact, I would argue that it is this division more than any other, more than Iraq or Social Security or education, that led to the divisiveness of the last election. There are 2 questions involved here, national security versus civil liberties, and are we at war or are we engaged in a law enforcement operation? As an aside, let me note that it's to the best of my knowledge, Congress has never declared war since World War II. Indeed, I don't think anyone has declared war since 1945. It's a concept that has disappeared. This means that the clear-cut division between being at war and being at peace no longer exists. Instead, we have endless arguments. Are we at war today or are we not? It is a reasonable argument to have. One can maintain either side of it. I believe this is a mistake. We should return to the declaration of war and make it clear. There is also a legal machinery that goes into effect when war is declared, which does not now exist, and as a result, we are engaged in legal ad hocery. The differences between liberals and conservatives on this profound point, are we at war or are we engaged in a large-scale police operation, was symbolized by the 2 presidential candidates. John Kerry in January of 2004 described the war on terror as primarily an intelligence and law enforcement operation. He reiterated this point many times, most memorably in October 2004. He said, "We have got to get back to the place where terrorists are not the focus of our lives, but they're a nuisance. It isn't a threat that involves people every day, and fundamentally it's something you continue to fight. It's not threatening to your fabric, the fabric of your life." President Bush, in contrast, the conservative in this duo, has since September 11 steadily argued for the profound import of what happened that day. He has spoken of a long-lasting ideological struggle in which totalitarians use terror as a tool to intimidate the free. He sees the enemy's goal as nothing less than a war to destroy America. This debate has taken place on other levels. Richard Holbrooke, at the time considered to be a likely Secretary of State for Mr. Kerry, said that we're not in a war on terror in the literal sense. The war on terror is like saying the war on poverty. It's just a metaphor. To which the President responded, anyone who thinks we are fighting a metaphor does not understand the enemy we face and has no idea how to win the war and keep America secure. It comes down ultimately to a matter of personal experience and temperament. Asked how 9/11 had changed him, Mr. Kerry replied, "It didn't change me that much at all." In contrast, Mr. Bush stresses how profoundly that day has changed his outlook and his sense of purpose. "I made the pledge to myself," he says, "and to people, that I'm not going to forget what happened on September the 11th. As Fred Barnes put it some time ago very succinctly, George Bush is a September 12th person, John Kerry is a September 10th person. By which I understand that on September 11th, some people, mainly conservatives, came to the conclusion that we are at war and must give the emphasis to national security. Others, mainly liberals, concluded that this is a large-scale police operation that should not affect civil liberties fundamentally. This difference pervades the debate over civil liberties. If the United States is engaged in a war to the death with ruthless totalitarian enemies who seek to destroy America, as the President maintains, national security will trump individual liberties far more often than if this is a nuisance that is, quote, not threatening the fabric of your life, unquote. Many, many examples illustrate this divide, but I'd like to take one that is very new, very raw, and notable. In fact, it came just this last week, namely the arrest of one Ahmed Omar, or the indictment of one Ahmed Omar Abu Ali. It serves as a kind of Rorschach test for this debate. Abu Ali, 23 years old, was accused or indicted on Tuesday of plotting to assassinate the President of the United States. He was born in the United States to Jordanian immigrant parents. He went to something called the Islamic Saudi Academy in Northern Virginia, a Saudi-sponsored and run school. He emerged in 1999 as his class Victorian. It is a small piece of Saudi real estate in America, a place where students are taught that Christianity and Judaism are, quote, false religions, unquote. He studied Islam then at the University of Medina. He went to Saudi Arabia itself. His fervent hatred of the United States apparently led to his joining up with al-Qaeda. He has connections to what is often called the paintball jihadists of Northern Virginia. He was not indicted in that for lack of evidence. Islamist organizations like the Council of American Islamic Relations have jumped on his case. He was arrested in June of 2003 in Saudi Arabia in the aftermath of a terrorist attack there. The U.S. government believes it is proof he was in touch with al-Qaeda and planning to attack the president. The indictment says that Mr. Abu Ali talked about assassinating Mr. Bush either by getting, quote, close enough to the president to shoot him on the street or figuring out a way to kill him with a car bomb. Now, I take something like this seriously. I don't know if he's guilty of this or not, but it certainly fits into a larger pattern of terrorist potential attacks on the United States. I am very happy he was apprehended. I'm very happy that this purported plot did not get anywhere. It seems to me it is a major victory. But on the other side of the argument, there is very little concern about this assassination plot and obsessive interest in procedural matters. I'd like to read you extracts from 3 editorials that came out this week. The case of Ahmed Omar Abu Ali from the New York Times. His case seems to be another demonstration of what has gone wrong in the federal war on terror. The Times then focuses on allegations strenuously denied by the U.S. government that he was purposely left in Saudi Arabia so the authorities there could torture him. If the Justice Department believed that Mr. Abu Ali was a serious terrorist, he should have been brought back from there long ago for trial. Instead, he became part of an unknown number of prisoners who were swept up by American officials or foreign governments working with Americans and questioned in the wake of September 11th. No concern here by the New York Times that an Islamist trained in the United States by an agency of the Saudi Arabian government stands accused of a plot to assassinate the president. No thoughts about the vast implication of this fact. Not a word of praise to law enforcement for having broken a possibly major terrorism case. Only exclusively interest in the evidentiary procedure. only fixated on civil liberties. Washington Post, same thing. On the same day, the 24th of February, unveiling a terrorism case. Mr. Abu Ali has alleged that he was tortured by the Saudi. Federal prosecutors denied this claim, but there's various evidence to confirm the use of some physical and psychological pressure tactics, and on and on. The entire editorial is exclusively on the topic. Baltimore Sun goes further the same day. By unsealing a federal indictment against Ahmed Omar Abu Ali, the U.S. government garnered headlines about an alleged terrorist plot. Get the irony dripping here. Instead of the unexplained imprisonment of an American citizen in Saudi Arabia, by producing the 23-year-old Islamic student in a federal court in Virginia on charges he conspired to kill the president, drip, 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 it portrayed Mr. Abu Ali as someone other than a victim of torture. The government may think it's secret, it's safe, but it isn't. Ha, gotcha. Also indicative of the liberal press are the headlines behind the day before the story of Mr. Abu Ali's indictment. Chicago Tribune. U.S. citizen charged with plot to kill Bush. The Guardian of London. American accused of plotting with al-Qaeda to assassinate Bush. New York Times. American accused in a plot to assassinate Bush. Detroit Free Press is my favorite. Valedictorian suspect in plot on Bush's life. Now, these headlines are slightly misleading in that it was neither his citizenship nor his class rank that are keys to understanding his motivations. A useful headline would be something like, Islamist charged in plot to assassinate Bush. My belief is that we must face up to the fact that we are in a war, and that we're not in a war on a faceless terrorist enemy, but that there is a specific nature to this enemy, and it is radical Islam. It is not Islam the religion, it is not terrorism the tactic, but it is radical Islam the ideology. Its followers have declared war on us. They are skilled, devoted, and ruthless. They are a worthy enemy. We must focus on the Islamists. The pool of likely, the natural pool from which Islamists are drawn, I'm afraid, is Muslims. This leads us all as Americans to be extremely uneasy, but it is a fact that the Islamists come from among the Muslims. Just as if one is looking for rapists, one looks only at men. If one's looking at Islamists, one looks only at Muslims. This is a matter of fact, and it is for the safety of all, including Muslims. Let me draw a couple of conclusions, that there are profound changes underway in warfare. We've heard some mention of it here. We're not going head-to-head with serried ranks of uniformed enemies. This has meant a rethinking of war in the Defense Department, but it also means a rethinking of war in the Justice Departments. Laws must change. We don't declare war anymore, for example. This is a difficult process. Dr. Levy mentioned law on the fly. Professor Goldsmith talked about groping towards solutions. This is what we are doing. We have no choice. Today's debate is part of that process. We need to tolerate mistakes. We will make mistakes. There will be innocent people in jail incommunicado for a year. But what is the choice? If we don't take these steps, we are vulnerable to the most atrocious attacks. I would rather, personally, see a few people, or even many people, innocent but in jail, than I would like to see more events such as 9/11. Thank you.
That was the easiest job of timekeeping I've ever had. I've been an appellate judge now for 9 years, and I've never had 4 consecutive speakers stay within the time limit. What we had originally planned to do was to not have rebuttal because Dr. Pipes has to leave at 2:45, and so we're going to open it up for questions. But as those of you that are beginning to formulate your questions, get yourself in place. Professor Strawson has asked just for a brief opportunity for a series of questions in between the panel itself that will begin to formulate the debate. So Professor Strawson, you want to ask a question?
Oh, well, actually, could I make some comments?
Yes.
Is that kosher? I can always frame them in the form of a question if necessary. We know that art. I wanted to have the chance to raise a couple of points in response to Dan Pipe's interesting presentation. And one very important point is his notion that liberals, and using John Kerry as an example, underestimate the real danger of terrorism. Whether or not that's true of liberals, I have to say that false assumption is absolutely not any part of the ACLU's position on these issues. We very much do believe, unfortunately, that there will be further terrorist attacks, and that is particularly important, therefore, that we critique the measures that the government is putting in place to make sure that they are at least effective. And unfortunately, many national security experts have agreed that too many of these measures are the worst of both worlds, that they are scapegoating civil liberties without going after the actual causes of the attacks. And the best example, I think the best known example, is the critique that's been made by Richard Clarke. With respect to the New York Times editorial, Dan, I must have read it. I don't have it in front of me the way you do. But my recollection, either of that editorial or others that I read from the so-called liberal press, was that the critique was not only that the gentleman's rights were violated, but also that therefore it would be more difficult for us to prosecute him. Because once evidence is obtained under torture, there are credible allegations of torture. First of all, those kinds of confessions are notoriously unreliable, as experts in intelligence themselves say. And secondly, it becomes impossible under our Constitution to proceed with the prosecution. So it wasn't as if the concern was only about civil liberties. And then the final point with respect to, I'm not sure exactly what you mean by Islamists. I assume you mean people who are terrorists, who also are Muslims. But I thought your analogy to rapists and men proved too much, as we lawyers say, because if that were a fair analogy, then I assume you would support the interrogation, surveillance, and deprivation of civil liberties of all men, just because all rapists are men, quote unquote.
Dr. Pipes, I'll let you answer, and then we'll go to the questions. Dr. Levy and Professor Goldsmith, I have a feeling that you'll get in play here in a minute anyhow. Go ahead.
I cannot address the question of what the ACLU's position is. All I can say is that I have been disrupted by one of your staff at a speech I gave a year ago at American University when I was giving my ideas on the war on terror. You can go to my weblog and see my January 20th speech.
That's absolutely untrue, as you know, and you were good enough to publish the actual facts in a letter by Anthony Romero, our executive director.
He was not doing it on
weblog.
staff time, I acknowledge, on his own time.
And he was not disrupting. It was a silent protest, which I would certainly defend everybody's right to engage in, as well as your right to engage in noisy exercise of your free speech.
He actually was disruptive.
Go ahead, Dr. Pipes.
So, on the point about the New York Times editorial, the key point here is that we have a spectacular headline that someone has been arrested in an attempt to assassinate the President of the United States. And the New York Times, as well as the other editorialists, did not pay any attention whatsoever to that news, only to procedural matters. As far as Islamists are people who support radical Islam. It is not the same as terrorists. You can be an Islamist without being a terrorist. But the terrorists whom we are confronting are I mean, there are other terrorists for other reasons, but the strategic enemy of the United States today is radical Islam, and it is partly through terrorism and partly through other means.
I knew this was going to be a great panel. I was so glad I was assigned to it. A colleague from the D.C. Circuit, Judge Santel.
Professor Pipes, in your otherwise excellent presentation, and I say that with no hint of irony at all, heartfelt, in fact, but there is a repeated theme of going back to the days when we declared all wars. There was never such a day. We've had 5 times that we declared wars in U.S. history. We had our first undeclared war as our first war after the Revolution. The quasi-war with France, the naval war, was during the Adams administration. The Supreme Court passed on whether or not that constituted a war and said it did, and they didn't have to be declared, and that was the Supreme Court before John Marshall. Now, what I would do to convert this into a question so it becomes legitimate to be up here is ask
Thank you,
Probably
Judge.
Professor Goldsmith, but you can comment if it's even possible to declare a war where the enemy is not an identifiable nation state. Undeclared wars existed between nation states even before the United States, but I don't know of any time that a nation state has declared a war without an enemy nation to declare it against. Professor Goldsmith, you might.
I agree with what Judge Sintel said. There's no doubt that we are in, as a legal matter, not as a normative matter, we can argue whether we should be or not, but there's no doubt that we are in a war now. The September 18th, the authorization to use force, which I mentioned, is as broad as any of the authorizations to use force in the history of the country, including the authorizations to use force in declared wars. That's the first point. So as a legal matter, perhaps not as a social matter, but as a legal matter, we are in a war. Second, one of the reasons there hasn't been a declared war since World War II is because the primary purpose of a declaration of war had to do with status and rights under international law. It wasn't designed primarily, that was the primary purpose. And since the UN Charter, war has been, as a category, has been eliminated. And that's why there, in fact, hasn't been a declaration of war since, one of the main reasons there hasn't been a declaration of war since World War II. Third, I don't know of any instance of a declaration of war being, of a war declaration against a non-state actor. There have been plenty of examples in U.S. history where the Congress has authorized the President to use force, just as it did on September 18th, against non-state actors, against Indians, slave traders, pirates, and the like. And the last thing I'll say is, however, that although I don't know any examples of states declaring war on non-state actors, Osama bin Laden and Al-Qaeda did twice declare war against the United States.
Okay, remember the rules. State your name, the school you're from, and then let's have a question. To my right.
Mike Paulson, University of Minnesota Law School. I have an honest question for Jack and a trap question for Dr. Levy. They both have to do with Padilla and Hamdi. My honest question about Hamdi is the right of due process is not textually limited to citizens. Do you read Hamdi as essentially creating a hearing right for every POW, wherever captured and held in the world, to determine that POW status, combatant status or not? And the trap question is to Dr. Levy, do you regard the United States as a battlefield theater in the post-September 11th war on terror?
I don't read Hamdi that way. Hamdi itself explicitly limited its analysis to U.S. citizens who were detained in the United States and captured on a traditional battlefield. So technically, Hamdi does not extend to that. And I don't think it will be extended to non-U.S. citizens captured and detained outside the United States, in large part because there's a very good argument that the Due Process Clause does not apply to non-U.S. citizens outside the United States.
Well, let me comment on that part of it first. I don't read Hamdi to give everyone a right to due process, even non-citizens apprehended outside the United States. But I think a plausible reading of Rasul might be to advance that right. If you recall, in Rasul, the Supreme Court accepted the case to resolve the jurisdictional questions, that is whether or not federal court had jurisdiction over Guantanamo. And Stevens wrote that the federal courts have jurisdiction to determine the legality of the potentially indefinite detention of individuals who claim to be wholly innocent of any wrongdoing. The interesting part of the Guantanamo case, he distinguished his ruling distinguished the Guantanamo situation from Johnson v. Eisentrager, and then he went on to say, not asserting a constitutional right, but a statutory right. He said instead of considering the constitutional right, he said the detainees have a broader statutory right under a case called Braden v. Kentucky, and basically habeas jurisdiction applies wherever there's a custodian within reach of service of process. And he further said that the habeas statute doesn't distinguish between citizens and non-citizens. So if you put those two things together, then habeas can extend, as Scalia put it, to the four corners of the earth. And that was included in Scalia's spirited dissent in that case, which was joined by Rehnquist and Thomas. So the Guantanamo cases may stand for the incredible proposition that all persons anywhere, even outside the United States, even battlefield detainees and combatants have statutory habeas authority to challenge their detention. I can't imagine that that's what the court meant, but you could read the Guantanamo case to mean that.
And I think that there are two ambiguities in the opinion. One, the court, it's not clear, it's just not clear from the opinion, it's ambiguous, whether Rasul, the statutory habeas rights that Rasul recognized extend beyond Guantanamo Bay, because when the court was addressing the question what about the presumption against extraterritoriality, which it left open might still apply, it said, well, whatever that presumption means, Guantanamo is not outside of U.S. territory for purposes of that presumption. So they left themselves open that possibility. And the second is, of course, although there was a footnote that caused some a lot of talk, the court did not address what substantive rights may be available abroad. Just talk in terms of statutory habeas jurisdiction extending abroad.
It is the case, though, in Hamdi that Justice O'Connor's opinion specifically indicated that it was not a battlefield determination and that there was not a desire to interfere with the actions of field commanders with regard to the identification of enemy combatants. So you might want to consider that in your calculus. Professor Strawson, you want to say something? Then I'm going to want to take up any questions that we have for Dr. Pipes, because he's going to have to leave. Go ahead, Professor Strawson.
Well, I just wanted to add that in the D.C. District of Columbia decision that was issued last month by Judge Green, in the Guantanamo detainee case, she did reject the government's very narrow reading of the Rasul case and read not only the concurring opinion but also the Supreme Court majority opinion as making a substantive conclusion that these non-citizens were entitled to substantive constitutional rights.
Okay, great. Anyone who has a question for Dr. Pipes, I'm going to give you a move up. Do we have a Dr. Pipes question?
Can I recast mine as a question for Dr. Pipes?
Well, hang on. Is this a Dr. Pipes question? You've had one shot at the apple. Is this a Dr. Pipes
yes,
question?
Yes, this is a Dr. Pipes question. David Schifrin, Penn Law. Should we suspend habeas corpus? That would solve all of the procedural issues.
As I indicated at the end of my talk, I think we are groping our way towards a solution. I don't think anything quite so drastic as that is needed, but we do need to understand that we are in process. Let me give you an example. I don't know what the rate of conviction has been for those arrested on terrorism-related charges, but my guess is it's pretty small. It's a lot smaller than normal criminal conviction rate would be. We need to figure out, is this something acceptable? Are we ready to accept, say, a rate that's 1/3 of conviction, 1/3 as high as normal, because the stakes are so large? These are questions that yet lie ahead of us, and assuming, as I think we all do, that this is a war that we'll be engaged in for some time to come, I see us as the beginning of a long process of political and legal adjustment to these new realities.
One conclusion from lack of conviction could be that there's lack of evidence, and in fact, you seem to think that there should be a presumption of guilt. Why do we? And I think what's really striking is we do have statistics of the thousands of people who have been detained on suspicion of terrorism or alleged suspicion of terrorism. None of them has even been charged. I'm talking about all of those thousands who were swept up right after 9/11. That the Inspector General of the Justice Department itself were detained only because of racial and religious and national
Let me
origin.
be specific. On September 12th, 2 Indian Muslims riding on a train in Texas carrying $5,000 in cash, black hair dye, and box cutters were stopped, and they were kept for a year, and they were put through the ringer. They were both released eventually, and they were pretty bitter about their experience. They were asked a lot of questions. They were not treated very nicely, and they were let go. The question each of us needs to address individually and we as a society is, do we want those two who were suspected to have been, given the circumstances, possible al-Qaeda members, do we want them to have been put through that ringer or not? They were innocent, it turns out. I personally am glad they were put through that ringer. I think that's a price that we as a society want to pay for it. But again, this is the sort of question that has not yet been addressed.
Okay, to my left. Thank you.
Thank you. Michael Tracy from Concord University. With regards to direct battlefield action, during the Civil War, General Grant, as the military governor of his district, ordered all Jews deported from his district. That was in effect for roughly 2 weeks before President Lincoln rescinded the order. Was General Grant's battlefield command constitutional? And if not, under what principles and what procedural safeguards would be in place for the deported people?
I don't know much about this. I've never heard of this before. Had martial law been declared? Had the suspension of the writ of habeas corpus, had the writ been suspended?
It was just in his military governor district, so he would have had martial law at that
So it sounds like martial law was declared, and it was in the South?
No, it was from the northern province.
Oh. That is more problematic, constitutionally under Milligan, probably. If it was in the South, there might not have been any, at the time, any available legal restriction. If martial law had been properly declared in the South. In the North, it sounds like there would have been, it would have been difficult under the basic principles of Milligan.
Lincoln's suspension of habeas corpus during the Civil War was declared by Judge Tawney in Merriman to be unconstitutional. Now, there wasn't a matter of how to enforce the writ. Lincoln decided he wasn't going to respond to anything that Tawney said in that regard. And then a couple of years after the fact, Congress retroactively said that Lincoln was justified in doing what he did. So I think it's acknowledged pretty much that Lincoln did unconstitutionally suspend the writ of habeas corpus. Of course, Lincoln's argument was, I'll suspend one part of the Constitution if by doing so I can assure that all the other parts will remain valid and enforceable. And you can make, after the fact, a good argument for what he did. Nonetheless, it was unconstitutional, and it was, after the fact, declared to be okay by the Congress, notwithstanding the court's declaration of unconstitutionality.
Lincoln's suspension. Go ahead. Go ahead.
I haven't heard of this either. Can you tell us what was the alleged rationale for it?
General Grant felt that Jews were profiteering and funneling cotton profits back and forth across. So rather than to find out which ones were engaged in the illegal profiteering, he decided it was better to
and just tell me, what state was it in again? What district?
It was in, he had a military district that covered 3 or 4 states as well as an unincorporated area. What was that?
They were in the North?
Yes, they were in the North and the unincorporated areas.
Go ahead, Dr. Lee.
I want to comment briefly on the last question as to whether Congress ought to suspend habeas corpus. I think, by the way, that there's some considerable question as to whether Congress can do so. There's no question but that in the Constitution, Congress is charged, is given that power to suspend the writ of habeas corpus. But you may recall in reading the Constitution that it can only do so, it says, and I quote, when in cases of rebellion or invasion, the public safety may require it. Now, I wonder whether reasonable people would assert that we've experienced a rebellion. If you look at rebellion up in the dictionary, which I happen to do, I don't know why I was looking at this particular issue, it says an uprising intended to change or overthrow our existing government. I doubt that we've had that. Invasion, entry by force in order to conquer the United States. Well, have we had a rebellion and invasion? Well, I'm not sure that we have. And even if somehow 9/11 were deemed to be a rebellion or invasion, I doubt that we could make a plausible case that public safety requires a suspension of habeas corpus when we have the federal courts that are perfectly functional and perfectly able to prosecute the vast majority of these cases. Now, that is not to say that nothing should be done. As I indicated in my remarks, I think Congress needs to step up to the plate and establish some new rules in this regard. I mean, we are involved in a new ballgame. There are people running around potentially with weapons of mass destruction. We can't be governed by the same old rule. But we can't have the executive branch unilaterally declaring what these rules are going to be. If I can take 20 seconds?
Sure.
20 seconds, just a framework for, I'm not suggesting that these are what the rules should be, but these are the kind of things that I think Congress ought to look at. In order to justify the detention of somebody like Hamdi or Padilla or even or a non-citizen even, we ought to have a responsible official of the United States government, by that I mean the President, the Vice President, or the Attorney General, certify that there's a reasonable belief that this guy's a member of an international terrorist group and that his release would endanger public safety, and that they can't prosecute him for a crime either because they don't have the evidence or the evidence is inadmissible or it's classified information. And then there has to be, even if the responsible official makes that certification, there has to be some procedural safeguards, like, for example, no more than a couple of weeks, maybe 3 weeks, 4 weeks, without an attorney, non-punitive quarters, compensate this fellow if he turns out to be exculpated, and then only allow that to be renewed beyond the 3 or 4 weeks, whatever the time period is, if he gets an attorney and the federal government makes this case before an open court with the assistance of counsel and the right to introduce exculpatory evidence and call witnesses. That's the kind of framework that the legislature, the Congress, ought to flesh out so that we do have a paradigm for this new world that we're living in.
On suspension of the writ, while I agree with Bob's analysis that one could make a strong case that the constitutional conditions don't apply, I think it's important to note that the Scalia-Stevens opinion in Hamdi, which took a very strong position that in favor of civil liberties, also said that in essence it would be a non-justiciable political question completely for Congress to decide whether the conditions for suspending the writ obtained or not. And of course, Justice Thomas weighed in on that point. So I don't think we would get judicial review. I think there would just be deference to Congress's determination.
I think that has to be right. That has to be right.
I knew there'd be a long line today. Thank you for the question. Go ahead.
Good afternoon. I'm Freddie Torres from Pontifical Catholic University of Puerto Rico Law School. The ACLU chapter in Puerto Rico presented a movie titled Unconstitutional. A very strong case for the unconstitutionality of the Patriot Act. However, I'd like to see if the ACLU, if it's the case being so strong, have they used that to attack the Patriot Act itself? And another part of the question is, the terrorists have declared war on the United States, and one of the ways they could win is by actually taking away what it is to be American, which is our freedom. It's kind of ironic to see if the government or the Patriot Act can be interpreted as a victory for the terrorists, and in fact our own government might be taking these actions for them.
Exactly. Well, again, we haven't challenged the entire Act as being unconstitutional, and there are certain justiciability problems that make it impossible to bring lawsuits against every single provision we do believe is unconstitutional. So we're working for legislative fixes, but we have brought lawsuits against 2 specific provisions. One is Section 505, which allows the national security letters, which I mentioned in my opening remark. A judge did strike those down on First and Fourth Amendment grounds. The government is appealing. We also challenged much earlier Section 215, the notorious provision that librarians, among others, are complaining about, where there is some judicial review, but it's in an ex parte proceeding before the super secret FISA court. And there, even though we filed that lawsuit a couple of years ago, the court still hasn't ruled. That's a little bit frustrating. We also supported the Center for Constitutional Rights lawsuit against a provision that is, and the lower court agreed with all of us, an unduly vague and overbroad definition of domestic terrorism, which results in stifling First Amendment freedoms.
Charles Ruggie from Georgetown Law School. Professor Goldsmith underlined the distinction between civilians and soldiers. Combatants, thank you. And the laws of war state that prisoners of war cannot be questioned, interrogated, and certainly coercion can't be used against them. Meanwhile, civilians are, the interrogation of the civilians is clearly limited, and coercion is also very curtailed. It seems as though these illegal combatants have fallen into another category in which both free interrogation and coercion are permissible. Is the catastrophic threat they pose justification sufficient for this? And if so, what is the limit that you think should be imposed on coercion?
He has to go ahead, Goldsmith, and then Lee.
That's a very big question. The reason that Al-Qaeda members fall within a gap is because the Geneva Convention, and aren't, in my view, covered by the Geneva Conventions, is that the Geneva Conventions set up a system that tries to promote compliance with the laws of war. And the system is basically, if you comply by the rules, you get protections. You get combatant immunity, you get POW protections and the like. And it set up that system because precisely to promote compliance with the laws of war. It's because Al-Qaeda, A, is not a state and is engaging in warfare. The Geneva Conventions are limited to states. And B, because they have failed to comply with the laws of war in waging their war. It's precisely for those reasons they've made the choice and they have forfeited the protections that they may have had under the laws of war otherwise. So that's the reason for it. As to what should govern in the absence of that, that is a very difficult question. I don't have a short answer to that. I basically think that in most contexts, the rules of Article 75 of the Second Protocol or Common Article 3 of the of the Geneva Conventions provide a good template for basic safeguards of rights in this context. I wouldn't say that the United States is bound by those rules. We've explicitly rejected Protocol 2 precisely because of the protections it conferred on terrorists. But I would also mention that while both of those protections I just mentioned prohibit torture, they do not prohibit coercive interrogation.
Dr. Levy?
Let me just say why I don't think this enemy combatant distinction that you made, and which Professor Goldsmith has referred to, holds water, in particular in the Padilla and Hamdi cases. Basically, enemy combatants are either POWs or they're unlawful combatants. If they're POW, they got to provide name, rank, and serial number, and they got to be repatriated at the end of the war unless they've committed war crimes, in which case they get tried, but they get tried under the Uniform Code of Military Justice. Unlawful combatants are completely different. These are guys that don't agree to abide by the law of war. They don't have any. They don't bear open arms. They don't have any insignia or any kind of command structure, and they don't get very many rights at all. And if there's a dispute, and this is the rub, if there's a dispute as to whether or not they're an unlawful combatant or POW, then the Pentagon regulations in 1997, which are modeled on the Geneva Conventions, specify that there's a screening tribunal that's supposed to be convened, 3 officers, and a written record, and the detainee has a right to the interpreter and can testify and can call witnesses, and there's a majority vote of this screening tribunal. Instead, the administration unilaterally decreed that everybody at Guantanamo would be treated. Was not covered by the Geneva Convention, even though Judge Joyce Green has just recently, a couple of weeks ago, I think, said that what matters is where the conflict occurs. In this case, it was in Afghanistan, and since Afghanistan is a signatory, the Geneva Convention does apply. The Bush administration said no. What was the justification for the Bush administration treating enemy combatants separately and decreeing that the Geneva Convention didn't apply, and neither did the 1997 regs? It said we look at the Quirin case that Professor Goldsmith commented upon. But the Quirin case, that was this one where the Nazis were captured, and 6 of them were ultimately executed, and at least one of them was an enemy, an American citizens. But there are a lot of differences between the Quirin case that occurred in 1942 and the current situation. First of all, the Quirin case addressed the question of whether they could be tried by a military tribunal, not whether they could be detained indefinitely. Padilla, for example, was never charged, much less was he tried. The Quirin case doesn't give any legal authority at all for detaining a citizen indefinitely without an attorney solely for interrogation. The defendants in Quirin, they had judicial review, they were represented by counsel, they were tried by a tribunal, and that tribunal was expressly authorized by Congress, which had also declared war. So there's a lot of differences. Today we have no declaration of war, we have no suspension of habeas, but we do have, which we didn't have at Quirin, we didn't have at Korematsu, we do have this Non-Detention Act, which says that the executive branch can't do this unless Congress consents.
I'm sorry, does that mean you don't believe there should ever be a case in which they could be interrogated and coercion used?
No, as I indicated with my previous answer, I do believe that there should be a case in which they can be detained and interrogated, but Congress has to set those rules. It can't be unilaterally decreed by the executive branch, and that framework that I laid out is, I think, a starting point for Congress.
Dr. Levy, let me ask you, do you disagree then that the joint resolution for the use of force on September 18th, which Justice O'Connor found as the linchpin for Hamdi's detention, doesn't authorize his detention or doesn't authorize the detention of an American citizen who may have an affiliation with either the Taliban or Al-Qaeda?
I agree in Hamdi's case that the authorization for use of military force, which occurred post 9/11, triggered the President's commander-in-chief power, and that power could be construed fairly, which the court did construe it in the Hamdi case, to extend to taking enemies, combatants on the battlefield in Afghanistan and detaining them. I don't agree that that extends to, as one of the somebody characterized as a trap question, whether that extends to O'Hare Airport. And I don't agree that the detention of combatants in Afghanistan obviates the 1997 Pentagon regulations or the Geneva Convention, which says that in the determination of whether they're POWs or they're unlawful combatants, you have to go through some procedural hoops, which the administration didn't go through.
But why don't you believe that? I mean, what is it in the authorization to use force that you think authorizes the President to detain Hamdi but not Padilla?
The question is not whether the President's authorized to use force. The question is whether the President is authorized to detain an American citizen without charges indefinitely. And in the case of Hamdi, since he was a battlefield combatant, and since the President had an express authorization, which is required by the terms of the Non-Detention Act, Congress has to consent. Since there was an express authorization regarding the use of force in battlefield conditions, then I think Hamdi's covered. But I think it's a very much of a stretch to extend the authorization for the use of military force to suggest that an unarmed non-citizen alighting from an airplane in O'Hare Airport comes under this authorization for detaining battlefield combatants.
Go ahead, Professor Goldsmith.
I'll respond to both, I'm sure.
Okay. I just wanted to add the reason why it seems unlikely that that's what Congress intended, aside from the exact wording of the resolution, is a reason that was pointed out in the Souter-O'Connor opinion in Hamdi, which is within a month, Congress passed the USA Patriot Act with overwhelming majorities, and the USA Patriot Act imposes very severe limitations on the extent to which even non-citizens can be detained. So why would Congress impose these limits? I mean, and I have to say the ACLU didn't think those limits were sufficient, but why would Congress on the one hand say there have to be these limits on the extent to which non-citizens can be detained, but we're allowing under this very vague language open-ended, indefinite detention, perhaps forever, for the rest of his life of an American citizen?
Professor Goldsmith, I'll give you the last word.
The answer to that question is, I don't have the language of the Patriot Act in front of me, is that those restrictions on detention extended beyond persons who are enemy combatants. That's the answer to that. The answer to the authorization to use force is that I just don't understand how you can draw a distinction between Hamdi and Padilla, assuming that Padilla is a member of al-Qaeda. That means he's a member of an organization that was responsible for the 9/11 attacks. That means that the President was authorized to use force against that organization and its members. That means that if force includes the power to detain, as the court said in Hamdi, I don't see why it's any different for Padilla.
Before we go to the next question, I would encourage, knowledge is power. Being intimately familiar with the joint resolution since I wrote the dissent in Padilla at the Second Circuit, I would encourage you to read the resolution, and I would encourage you to read the preamble which Congress authorized the President to prevent any acts of terrorism at home or abroad. Next question.
Hi, I'm Elizabeth Lewis from Harvard Law School, and my question is for Professor Strawson regarding the ACLU's concerns about the Patriot Act. I recently had the opportunity to hear a lecture and have dinner with David Kelly, who's the U.S. Attorney for the Southern District of New York, and also a lifelong Democrat, and he got a lot of questions throughout his lecture, hard questions about the library provisions and the surveillance and sneak and peek provisions, and he seemed to think that in practice the Patriot Act hasn't really changed anything and basically just codified the same practices that were going on prior to 9/11, and he's taken the lead on numerous terrorist investigations, and it seems like in theory we can be concerned about certain provisions, but if in practice nothing has really changed, that maybe there isn't that much concern, that we can trust the people who are taking the lead on these investigations. And I just wanted to see if you had any examples about in practice these provisions getting out of hand?
Well, first of all, if you think that we should rely on trusting government officials, then you and I not only have a personal difference, but that there is a difference that is reflected in the Constitution, which reflects a skepticism toward government. We do not rely on trust. We rely on the rule of law to constrain government power, not because we don't like particular individuals, not because we don't think that they're acting with what they consider to be the best of motives, but we are not going to entrust our precious freedoms to the discretion of government officials. I know exactly the arguments Mr. Kelly is making because he's citing from a briefing book that the U.S. Department of Justice put out early on under John Ashcroft's leadership. So I've debated him, I've debated many other U.S. attorneys, and Ashcroft himself, and they always make exactly the same arguments, which I find rather inconsistent, because if it's true that these powers already existed, why did we need what John Ashcroft himself called sweeping new powers under the USA Patriot Act? The ACLU has on our website a point-by-point analysis of the various provisions that we critique, responding to, and then the Justice Department responded to us, so you can link on to the Justice Department's analysis and then our reply, and we also show you the exact language of the provision. So you shouldn't trust us any more than I think I want to trust the government. Look at the exact language. Let me give you one example. Section 213, sneak and peek, since that's one that you mentioned. It is true that prior to the Patriot Act, there were a couple circuit court opinions that held that in particular situations, delayed notice of searches would be allowed if certain extenuating circumstances should be shown, such as a danger that somebody was going to flee the jurisdiction, a danger that somebody was going to destroy evidence, a danger to life and limb. And in those circumstances, the two circuit courts held that notice could be delayed for a very specific period. I believe the maximum was 1 week, subject to extension. Now, under the Patriot Act, no such reasonable limitations are put in place. There's no specific allegation that has to be made to justify delayed notification. Moreover, there's no time limit on how long the notification can be delayed. So this is a perfect example of how our proposed fix in the SAFE Act, remember I told you in my opening remarks, we're not denying the core of the government power. We're just imposing more judicial review and bringing it back into line with constitutional constraints. So the proposed fix we would have is if the government can show that one of a number of criteria are satisfied, including danger to life and limb, danger that the evidence would be destroyed, and so forth, then and only then the judge can impose a limit of only 1 week, subject to renewal if the government can come back and show that those extenuating circumstances continue to exist.
Great. We've worn someone down already, and I feel terrible about that. Let's take our next two questioners, and we might have 30 seconds for you at the end. Have your question been answered? Very good. Okay. Well, I'll see if you wait around long enough the question gets answered. Go ahead.
Yeah, I'm Richard Sobel, and I work on privacy at the medical school, Harvard Medical School. This is a question that to Nadine Strawson and Robert Levy, since both Cato and ACLU have talked about this in terms of civil liberties. The Intelligence Reform Act, which President Bush pushed through in the lame duck Congress, and now last week a number of immigration laws, have included provisions for what is called the National Driver's License, but is in essence a national ID card. The Cato has talked about this a number of times. If it looks like a duck and it walks like a duck, it quacks like a duck, it's a duck. And there's an even more draconian version of this in the immigration provisions the House has passed, which would make this required for both federal benefits and federal travel. I'd be interested in your analysis, particularly in terms of the coalitions of liberals and libertarians, for both of you, how you see this fitting into a sort of general statement of principles of liberty and how this challenges them, particularly federalism.
Well,
go ahead, Dr. Lee.
This it's called the Real ID Act, I think that's what you're talking about. It passed the House and now it goes to the Senate. It would promote it, of course, as a national security measure, but it's also intended, I think, quite plainly to curb illegal immigration and to even toughen some of the asylum provisions. It was sponsored by Sensenbrenner. It would force the states to issue federally approved driver's license with digital photos and machine-readable technology. There's an opt-out provision, but I think that's more apparent than it is real, because if the states opt out, then the licenses that the state issues are not going to be valid to board airplanes, for example, or purchase guns, or even to enter federal office buildings. So the states, by the way, if you're interested in federalism, have denounced this bill as both burdensome and expensive. But the more important thing is, if it's being promoted as a national security measure, it's unlikely to work. All of the 9/11 hijackers entered the United States legally. They qualified for valid driver's license, or they could have even used their passport. So the real impact of this is going to be on undocumented workers, and basically they're going to be forced to drive illegally now instead of legally, and drive without insurance. Terrorists, by the way, do not ask for asylum, so cracking down on the asylum procedures are not going to be very helpful. I think Homeland Security should be about preventing another attack, not keeping Mexican illegals from driving to their jobs, or preventing people from gaming the asylum system. I commend President Bush, by the way. I think his guest worker program is a step in the right direction.
Well, thank you, Richard, for all of your excellent work on privacy and the opportunity to chime in on the one point that Bob didn't answer in his excellent response, which is the very ideologically diverse coalition that has consistently resisted any kind of national ID card as far back as I can remember, going back to the Clinton administration, where we have worked not only with libertarians such as the Cato Institute, but also mainstream conservative organizations and even so-called extreme conservative organizations and religious right organizations, some of which have religiously based opposition, as you well know, but maybe not all members of the audience. And of course, gun owners' rights organizations are very deeply opposed to this kind of federal ability to track not only our movements, but all kinds of other information about us through this kind of ID system.
Last question.
Howdy. This is specifically for Dr.
Name and where you're from.
I'm sorry. Christopher Allen from George Washington Law School. And this question is specifically for Dr. Levy, but I'd certainly like to hear the rest of your input. You focused on the fact that O'Hare Airport could not be a battleground. But if the war is against al-Qaeda, and al-Qaeda has struck in Bali, Indonesia, Baslan, Chechnya, Madrid, Spain, New York City, it seems that the criteria for a battlefield is either A, where U.S. troops are on the ground like Afghanistan, B, no place in the world is a battleground against terror, or C, a place becomes a battleground when it is blown up. So, based on this, how can you justify that O'Hare Airport in a global war against terrorism is not a legitimate battlefield?
First of all, I didn't say that O'Hare Airport is not part of the battlefield. What I said was it's not covered by the authorization for the use of military force. Now, you don't have to take my word for it. Listen to Justice O'Connor in the Hamdi case. The authorization for the use of military force means, quote, O'Connor, the U.S. may detain for the duration of these hostilities individuals legitimately determined to be Taliban combatants who engaged in armed conflict against the United States. It doesn't say anything about a guy getting off an airplane at O'Hare Airport completely unarmed. Bear in mind that the Justice Department now, on the remand of the Padilla case, has abandoned the argument that O'Hare Airport is part of the combat zone. The Justice Department now says, indeed, Padilla did have weapons and did carry them in Afghanistan and was part of the Afghan, one of the Afghan combatants. So even the Justice Department now recognizes that the authorization for use of military force didn't extend so far as O'Hare Airport. And you remember the Hamdi case when it came up before the Fourth Circuit with Judge Wilkinson presiding in the Fourth Circuit. He made the statement, and of course he's an arch-conservative and I think supports the administration and did take a deferential view in the Hamdi case in the Fourth Circuit. But he said if you interpret the authorization of the use of military force to extend so far as your question suggests, then Katie, bar the doors. No one is safe from unlawful, from indefinite detention without any attorney, no matter whether they're a U.S. citizen. Whatever activity they're engaged in, the executive branch can unilaterally decree that this is indeed an act of an enemy combatant and whisk you away, sweep you off your feet and into a military brig where you will never be heard of again. And the administration argued that judicial review is not necessary.
May I respond to that, please?
Sure.
Just 2 points. One, 3 points. As to the last point, that the executive branch cannot do that after Hamdi. There's clearly going to be judicial review of enemy combatant determinations in the United States. As to the point about the authorization to use force, I'm still very puzzled about this. The authorization to use force does not have a geographical limitation. Lots of authorizations to use force in the past have had geographical limitations. The authorization to use force from September of 2001 has exactly the same form as the authorization to use force associated with the declaration of war in World War II. It authorized the use of force against particular entities without geographical limitation. Just as the President could use force when a few of the enemy infiltrated the United States in World War II, as the Supreme Court confirmed in the Kieran case, I don't see any basis for distinguishing. There's nothing in the authorization to use force that has any geographical limitation, and the language quite clearly applies to someone the President encounters anywhere. And the last point I would make is that Hamdi clearly didn't, all Hamdi did was limit itself to those facts. It didn't say that facts beyond that weren't covered by the authorization.
And there you have it. This has been a great opportunity for all of us to explore the dynamics that are going to shape much of your legal futures. If one thing that we gain from the discussion today is to learn that your bright legal minds will have to be brought to bear on some very difficult legal issues. I'll remind you of the words of Mr. Lincoln on April the 15th of 1861 when he suspended the writ of habeas corpus and blockaded the southern ports. The dogmas of the quiet past are inadequate to the stormy present. As our case is new, so must we think anew and act anew, and that will be the challenge into the future for all of us. Thank you very much.
Nice job, Robert. Very good. Nice to meet you. Yeah, Alan, you got it. And the discourse was good and sharp and focused. It was wonderful. This is the way it should be. I'm sick. Yeah. Well, you get taken in. Chris, how are you? I've been waiting to meet you. Yes, I've been hearing about you. Yeah, college here and you. I have Kevin Love back here. Okay, so you're another one. I'm from here.